and that is the grand jury. Everything you wanted to know about it, but we're afraid to ask. We thought this would be a very timely subject, since all the grand juries are crawling all over Washington, D.C. I'll be honest, I'd be afraid to walk down the street. They're afraid somebody hand me a piece of paper would be a subpoena. Not that I know anything, but anyhow. So we thought this would be very timely. But before we go to our speakers, I need to make a couple of housekeeping notes to the membership. Because we changed the year back and forth, and there's been some confusion. Right now, as of today, it was decided that we will use January 1 to December 1st. So all members will be honored at the current rate, so that everybody, if you owe anybody anything, it's up on December 31st. So your dues are due now for January 1 to December 31st, so we can kick off the new year with a blast. Okay, enough of that. Does anybody have any questions about dues? Okay, all right. Other than that, does anybody have any suggestions for a topic they would like to hear for November? Any suggestions? No suggestions.
Bill had a suggestion.
I can't, does anybody have their hand up? I can't see. Okay. All right. But then without further ado, we'll put it back into the what's hot in the newspapers and find something there. All right. Our first, let me first introduce our. We are very fortunate to have our district attorney, Hillar. Okay, and next to him is retired assistant district attorney, Prem Buerns, who has quite a reputation with grand juries. And next to her is the outstanding criminal attorney in our community, Unglesby. There's still a little bit of pride left to go there. All right, why don't we start off with Hillar, and then we will go to Lewis, and then we'll come back to Prem after we do the wrap up. So Hillar, it's all yours.
How long does that take?
10 minutes.
That's a long time. Well, good morning or good evening, I guess. It's surely a pleasure to be here today, especially with these two folks that are next to me. I could spend at least 10 minutes to talk about Ms. Buerns. Ms. Buerns is not only an assistant DA, but she was the first assistant DA, and she was my first assistant DA. I really chose her because of her experience and her temperament and the knowledge that she had. Ms. Buerns has so much institutional knowledge of the DA's office, which includes her really specialties, not only trials, but the grand jury itself. This lady is a wealth of information, just a walking encyclopedia, and one that you can always turn to in very difficult times to ask a question, and she would give you the answer. And so we, as a city and the community, we're very fortunate to have Ms. Buerns serve in the roles that she served for the people of the state of Louisiana and City of Baton Rouge. So I just want to make sure I make that known. Lewis, on the other hand, he's on the other side all the time, but I was once on his side with him on a case. I learned a whole lot from this gentleman. He has a reputation as a no-nonsense lawyer. He is. He's very, very tough negotiator. He's very demanding, but he also works extremely hard. And I think the thing that you see about these two people, if you ever saw them prepare for a trial, ever saw their notes, it's down to the T as to what they're going to do. They follow that, and they are very, very talented people. Grand jury. The grand jury has been around for 800 years, and having read a little more about it today, it seems as if there are only 2 countries now that employ the grand jury any longer, and England's not one of them. It's United States and Liberia. Why Liberia? I have no idea, but that's where the grand jury is. In the United States, only around 23 of our states still use some form of the grand jury. Louisiana uses the grand jury, as it always has in the past, for 2 different purposes. One is as an investigatory grand jury, as you may want to investigate things that are going on. You want to keep that confidential have it secret from the person that you're investigating, potentially protect witnesses that are coming forward, and surely protect grand jurors in any type of deliberation that they want to take. But for the most part, the grand jury in Baton Rouge, as it's used, is more of an accusatory grand jury. That is, by statute, the district attorney is required to present cases to the grand jury that are either have death penalty associated with it or life in prison. So with a city that has the number of homicides that we have, which carries a potential life in prison or possibly death penalty, we almost exclusively use the grand jury at this point for homicide cases. Grand jury doesn't always indict cases. You see often, and Joe Guyan is here from the newspaper, and if you follow him, he follows the returns of the grand jury. And oftentimes, grand juries come back with a no true bill, because they've decided they would not, or don't want to move forward with the case. In a lot of cases for us nowadays, you'll find a grand jury does what's called a pre-commit. It is, they cannot make a decision. 9 of the 12 people must be present to deliberate, and that 9 must vote to move the case forward as a true bill, no true bill. And pre-commit means you cannot get 9. And in cases nowadays, particularly our homicides, where we have very few witnesses who do not want to come forward, but there's an arrest made that's based on probable cause, and we go to the grand jury to present them legal evidence for them to consider. They will return a pre-commit, that is, they just could not make a decision. That's bad news oftentimes for family members of homicide victims, where they want the grand jury to return a true bill. But for prosecutors, we want to make sure that we have a case that we can go forward on legally and ethically with the evidence we have. The good news for a pre-commit is that does not mean the case is over, that the case is dead, that if any further information comes forward, that we can go back to the grand jury and discuss that case further. Baton Rouge has 3 grand juries. One is a special grand jury, which is impaneled for a year and can be impaneled longer for 6 more months. And we also have 2 regular grand juries, which serves a shorter period of time. And we employ all 3 grand juries, particularly in Baton Rouge, having the Attorney General here. The Attorney General uses grand juries from time to time. And oftentimes they have longer, protracted investigations. So instead of them taking up one of our entire grand juries, I believe Ms. Buerns even was one that suggested that we have 3 grand juries in Baton Rouge. So we do. I think we may be the only city, possibly New Orleans, that may have 3 grand juries, but we use them. And we use them, unfortunately, very often. The knock on the grand jury is that it does whatever the DA tells them to do. And I'll let Prem, who's no longer at the office, explain if she believes it or not. But our order to the assistant DAs and to the grand jury is, we're going to present to you legal evidence. We're going to tell you what we think. However, we need you as citizens to make the decision. Do you believe that the evidence given to you, if unrefuted, is sufficient to go forward with charges? The grand jury only recommends to the DA that, Mr. DA, this is second degree murder, this is what I think you should charge them with. Immediately coming out the grand jury, once they make their return, the DA wants to, can just dismiss that grand jury. That it's just a recommendation to go forward. So, is there really a need for a grand jury? Well, in Louisiana there is, because of the statute that says we must go to the grand jury on these cases. Others will argue that there is no need, that it's outdated, and many states have gotten away from that. We believe that there is a need for both the accusatory process, for us to present this to a grand jury, let them make a decision, and investigative-wise, there are some cases, although rare here, that we would like to use the grand jury to investigate, to issue subpoenas, to have returns on those subpoenas. Again, like anything else, it's the people that you have that present cases. It's how you implement the program. If you are going to be unfair and want to just tell a grand jury, please indict this person, I would guarantee that more than likely they would go along with the DA's recommendation, who's the advisor to the grand jury. Our position is we don't want you to just rubber stamp something. We want to know what you feel as a grand jury. The grand jury is made up of people from all over the city, different walks, religions, sizes, colors, and that's what we want as a grand jury. We want them to really be a true sounding board for us. The one thing that we hate is if a DA were to go to a grand jury just to get an indictment. What good does that do for us or our family when we know we have no evidence to present to go, and we have left with the family to try to explain, hey, I had to dismiss this indictment, or the jury found them not guilty. Why did you go forward at the beginning? We found that it's so much better to be honest with these victims' families up front, to tell them the strengths and the weaknesses of your case. And although it's frustrating for them to hear, this is the only way to deal with victims and to deal with the public and to be fair to defend them. The one other thing that we have found, and we started before Ms. Buerns left, is officer-involved shootings is the biggest thing that's going on now in DA's offices. In the past, when an officer was involved in a shooting, particularly with a death involved, that case would be presented to a grand jury, and the grand jury would generally return a no true bill. Rarely, as you know, officers indicted because of many different reasons, law, in fact, mainly. However, when we present a case to a grand jury and the jury comes back and says no true bill, the public then doesn't really know, why did you do what you did, Mr. DA, a grand jury? We want to know why. So now, if it's clear to us legally and factually that this officer did not commit any wrongdoing, instead of just going to the grand jury and using it as a washing machine to just come out with an answer, we issue reports that are very detailed reports that tell the public exactly why we did what we did. And we make the reports available to the public along with all the police reports, the photographs, any type of scientific evidence that we have. We found that that has been more transparent and explains our decisions in much more detail than we ever could at a very short press conference to explain what we do. So again, I think the grand jury is a useful tool. It depends on the DA and the assistant DA that presents it to the grand jury, and they have to be fair. It comes down to district attorney discretion and how you present and how you see things. And I believe that we have a very talented and capable staff that is fair in their presentations to the grand jury. And the grand jury does know for us that if there are ever any issues, the grand jury would always call Ms. Buerns to report any inconsistencies or maybe an assistant DA they didn't think presented where they should, but those complaints have been extremely rare. So I'm here to support the concept of the grand jury, although things have surely changed in the landscape. And without that statutory requirement to go, there'd surely be a lesser need for a grand jury, but I think that that need will always remain for the investigatory side of the grand jury. Thank you.
Our next speaker for the defense is Louis Unglesby.
Good afternoon, thank you. I'm going to talk more about the federal grand jury system than the state grand jury system, because the state grand jury system, you elect your district attorney, and as an elected official, the people that work for him are semi-elected officials, and that they work under his jurisdiction. So if you have a good, honest, like we do, district attorney, you'll have a good, honest grand jury. Federal law is completely different. The concept of federal law as a grand jury that's investigating anything to make an independent decision is a sham, according to the Justice Department, that conducts them. The grand jury in federal court is going to do exactly as it's told. The concept of the grand jury, when we invented it back in 1155, was to prevent the king from influencing the public. Because, you know, the king was the hand of God and everything else, and so if they wanted to investigate somebody, they needed a way for the citizens to be protected, and you did that by having the king excluded. You know, the sheriff, who was the local king's hand, all those people couldn't be involved in the accusatory process. It was really to screen, evaluate, and free people from being improperly besmirched. Today, the grand jury is a tool, again, for example, in the federal system, of evidence gathering to ensure that they have a case that they can win. If you haven't been clear in your testimony or your conversations with the FBI agent when you were interviewed, whether it was a red card or blue card, they'll make sure that by the time you get to that grand jury, you're going to sell your firstborn child and it's a blue card, because it's got to be a blue card. So they've told you it's a blue card. If you don't say it's a blue card, you've committed perjury. All of you are familiar, for example, with something called search warrants. I can't go into any of your homes as a policeman unless I go to a judge and I have what they call probable cause. So I have to put down in a warrant and swear to it all the reasons I think there's evidence of a crime in your home or your business. That's a search warrant. That's what the state system works with. In federal grand jury, the FBI agent walks in, said, I'd like to know about ABC business. Mr. Grand Jury Foreman, would you issue a subpoena, please? And that's done, period. They don't know anything about what's in the ABC business. They have no idea what's in ABC business. They want to know what's in ABC business. So the grand jury's used, and now that you see on TV, remember it's supposed to be a secret, you see on TV all the FBI agents carrying out all the boxes from ABC business. Many times those boxes sit across from the federal courthouse, where the post office is, for months, gathering dust. But poor ABC business, in the meantime, has had its reputation destroyed. Grand juries in the federal system are intended to be intimidating. It's very rare. It's almost not unheard of. Never happened in my career. And I've represented all kind of people, you know, good ones and bad ones. Never are you called up and said, would you like to bring your client down to the grand jury on Tuesday at 3 o'clock? If they're after that person, if they want to harm that person, the preferred way to do it is to serve him or her at their child's soccer game on Saturday morning. Or go to 1512 Carrollton Street and 1508 Carrollton Street looking for somebody that you know lives at 1510 Carrollton Street with the FBI agents and the badges. It is never intended, I mean, I don't bite my tongue about this, it is never intended to be done as anything but a way to nail down sworn testimonies in secret so that whenever they're cross-examined, they can't change, to intimidate people and scare them into cooperating with the government, or else they are under investigation, and to gather evidence that they could never, or gather documents that they could never go to a judge and get. It's the start of an investigation. It's not based on, we really think we're investigating something. And it's usually, often, driven by personalities rather than activities. You know, we think Joe is probably a bad politician. We think he's probably corrupt. Why do we think that? I don't know. We just think it. So we're going to investigate it. You want to ruin Joe? You get a grand jury subpoena for documents, and you send it to the state, any state agency. It's a public record. How many of you, every time you pick up the newspaper where there's an investigation of someone in government, the headline on the B section will be grand jury subpoenas X. You know, the grand jury's raiding the Department of Health and Hospitals or the administrative agency or whichever thing it is. Remember, it's supposed to be a secret. Of course it's not. You know, just like the raid is not. Channel 2 is just not riding around the town. Oh, look, there's a bunch of federal agents. Let's stop there. It doesn't work like that. It's all intended, start to finish, to reach a certain result. This is the other thing people don't know. The indictment in state court, an indictment has a very prescribed set of languages set by the state, by the statute. And it's real simple. You know, Bill, on October the 20th, murdered Sam in the parish of East Baton Rouge on Mayflower Street. So you know everything right there. That's all it has to say. A federal indictment is written by the prosecutors, and it doesn't ever say Bill murdered Sam. If it's not at least, if it's a serious case, if it's not at least 9 or 10 pages thick, there's a mistake that's been made. Now, I'm a civil lawyer. if I could write down in a lawsuit all of the worst things I can think of about any of you, then have them rubber stamped by some authority, okay? And then that piece of paper go to the jury with the imprimatur of the judge handed it to him. Now, my real civil lawsuit is you had a car wreck, you know? That's all that matters. You had a car wreck, and we think you ran the red light. But instead, I put in there every kind of traffic violation in the history of the world that you might have included, how many wrecks you had in the past, how many tickets you'd ever gotten, all the inadmissible evidence possible. And I get to use my language. Then when we get to court, all I'm going to put on is that you ran the red light. That's all the jury will hear as evidence. But it gets this document that I've ghostwritten for the grand jury that tells every possible bad thing you ever did. The fact that I chose not to put on any of that evidence, the judge will not tell the jury, grand jury. He won't take that indictment, yank off 9 pages and hand them the 1 page that was actually the purpose of the case. They'll get the whole accusatory document signed by a fellow citizen. In state court, most charges are signed by the district attorney or the district attorney's assistant. Grand jury indictment signed by the grand jury. So the jury gets the jury, the prior jury's opinion, which is sprinkled into it all of the editorialism that the prosecutor thinks is a likely way for them to succeed. It is extraordinarily abusive, and no one disputes it. I mean, there's nobody in the Department of Justice that says, yeah, it's really fair, we set it up that way. It's intended to be completely one-sided. If you're ever on a grand jury, which I hope you're not, because it's a pretty arduous and difficult task, but if you are, you do have a lot of independent rights. You can ask for evidence. You can ask for information. You can say no, you know, to what you're told. But in reality, just through a combination of manners, you know, the prosecutor is the person meeting, the agents or the policemen or the people who you're dealing with. Okay, they're going to become your friends, you know, and they're going to become people that you have conversation with. So you're unlikely to say no to them based on nothing more than individual relationships. Thank you.
Thank you, Louis, and you will have a chance to rebut Prem. Our next speaker is Prem Buerns, who has handled some of the most high-profile grand jury cases in our parish. Prem.
Thank you. Thank you to my fellow speakers, the district attorney, and my off-time opponent in several cases, Mr. Unglesby, who also was one of my classmates at LSU. We were both in Section 1, our first year of 1974. And I remember Louis specifically. Louis would sit in the back, and I was so proud of him, not knowing him at all. But he would always challenge the people who ended up on law review and the professors, and made his presence known even to me as not one of their better students, but I like to think that Louis and I became two of the certainly the best litigators from that 1974 class. It was with great pleasure that I served as the first assistant to Mr. Moore for the entirety of his first term, and with Doug Morrow for the last year of his term, because part of the duties of the first assistant is to oversee the grand jury and to select with the district attorney the grand juries in East Baton Rouge Parish. So it gave me a lot of insight into that process. And let me just ask, have any of you ever been selected and served on a grand jury? Just as a matter of curiosity. Anyone can serve on a grand jury. It's the same qualifications that it takes to serve on a regular jury. You have to be at least 18 years of age, read and write the English language, citizen of the parish for a certain period of time, and not be a felon or under a felony indictment. So there are no special requirements. And the way it's done is that summonses, subpoenas, actually go out to a great number of people in the parish, and they just show up one day when the grand jury is picked in public, I might add. This is not a secretive process. It's done in an open courtroom, so anyone can watch the selection of the grand jury. The people who've been summoned just show up and appear. What I found was that very few people actually honored those summonses that were sent in the mail. So when the law changed and was a proponent, we went from a certain number of people that could be subpoenaed to a much higher number, so that we would have at least enough people to select a grand jury from, because a couple of times we got down to the wire and it looked like we were not able to select 12 people then and the 2 alternates that we needed. So we increased that, and at that same time I also increased the number of people that could be the alternates, because we need 12 people to serve on the grand jury for a period of either on a regular, it's 6 to 8 months, usually 8 months that we keep them for. And on the special, then the only difference between the two is their length of service. One serves for up to 12 months and can be extended, as Mr. Moore said, for another 6. And so what we have is just simply a difference in the length of their service. And we tell them that the regular would meet on Wednesday, the special on Thursday. We always had 2 grand juries meeting when I worked there. And then finally, I saw that there was a need for a 3rd grand jury when then Attorney General Buddy Caldwell was taking the CNSI case to the grand jury. And Buddy and his son said to me, we're going to need a grand jury for close to a year. And I was like, you can't hog one of my grand juries. We have so many murders in East Baton Rouge Parish, cases and rape cases. Anything that is a life sentence or the possibility of a death penalty, those have got to go to the grand jury. Under the U.S. Constitution, anything punishable by life and death has to be by grand jury indictment. And I think that's very wise. Prem Buerns should not be able to decide if somebody is going to a crime by life or death simply by putting her name down. I could do it for any other crime and could do that, but not for those very serious cases that require the consensus of at least 9 of our citizens. So we had the law changed to enact a 2nd special grand jury that could hear those cases, and that at the time was particularly for the Attorney General's use. And for example, I would imagine, although I am not a member of the Attorney General's staff or privy to any of that information, I would imagine if the Alton Sterling matter ever got to be presented to a grand jury, it would be done by the Attorney General to that special grand jury that would be actually allocated to him and to his office. And that was the reason for doing it, is that crimes expanded. Sometimes there are ongoing white-collar type investigations like the Attorney General committed. We like to use, when I was there, the other 2 grand juries for the, what I call reactive cases, not the investigative cases, but the cases where there had been a crime and we needed to indict for legal reasons, either a murder, 1st-degree murder, 2nd-degree murder, aggravated rape, aggravated kidnapping. Those types of crime are life sentence cases or the possibility of death for the 1st-degree murder and are required to be presented. What do you do? People are picked in the grand jury in public. No special requirements, again. It's a very simple process. There's not a lot of question and answers. The main thing is they call up 12 people, and now they call up 4 alternates, and they sit in the courtroom. Judge asks for their name, their address, where they work, their race, which is required to be given just for the record itself, and for purposes of just showing that it is a fair and impartial process. And the only real question is, can you serve for this length of time, or is it there a hardship? That's the main thing. You get out of grand jury only for hardship, and that doesn't mean, gee, I go to the country club and play golf one day. It doesn't mean anything like that. Or I have my Bible study that day. Really what it means is that someone who might be an hourly worker who would lose their pay and would not be compensated or someone that has an elderly parent, a young child, would have hardship and nobody else to take care of them. You can be excused for that reason. But it's over pretty quick. Not, some people will try to get out of it. Most of the judges will shave them, and mostly it's a process where the judge does all of the talking. We will look and whatever, and you get a feel for who might be a problem down the road, somebody who might say, I can do this, but you think, he's not going to show up or she's not going to show. They're going to make an excuse because they're having some problems right now. So they're picked. They're sworn at that point. We take them over to the grand jury room and give them an orientation and explain what they do. And that's to listen to the evidence. And if the law says the evidence must be sufficient for a conviction, for the grand jury to return a true bill or indictment. It's not like, well, Ms. Buerns put on some evidence, so that's good enough. It has to be admissible evidence, and it has to be provable evidence that will return a guilty verdict in a courtroom. And you're not allowed to you can use hearsay for a police officer. You don't have to put on every person who took a confession. The officer can say, I picked this person up. We did the ballistics in the case. He had the gun after we went to his house with a search warrant. Ballistics matched up, he confessed, or if there were cases of eyewitnesses, they did that. So they'll evaluate a lot, and we have usually those cases again that are murders and rapes. We also would take cases that I felt were possible negligent homicides, car accidents where there's a death. And quite often, I think all of you can put yourselves in that place, is that there may be a horrible accident, but it might be something that Lewis is going to file a civil suit on down the road, and it's not a criminal matter. So cases where we're not sure individually, or don't feel that it's my responsibility as one person, one DA, I bring it to a grand jury. I would rather have the consensus of those 12 people, which is fair, and make 9 people decide what to do. And as Hillar said, 9 may decide to say not a true bill, which means you didn't prove it, or you do indict with a true bill, or a pre-admit, which is a hung grand jury. It's like a hung jury, but a hung grand jury. Those, what we do too, we put our evidence all under oath, and the only people allowed in the room, which you may be interested in learning, is the prosecutor and the witness. If an interpreter is needed, the interpreter may be sworn to secrecy and come in. What if a defendant comes in? And that's a situation. The last person I had, a defense attorney, sitting in the room was probably Mr. Moore, back when he was a defense attorney. And he was allowed to sit in with his client while the client testified. He had to be given an oath of secrecy. And he could not make objections, as in a trial, but he could sit there. And if they needed to leave the room and consult about something, they were in a position to do that. But somebody who's a target can have their attorney in the room with them, but you have to maintain that secrecy. When the evidence is presented, I have got, and any DA has got to leave the room. We've got to let the grand jury deliberate in secrecy, and then they return whatever is done. It's returned in open court, and there's an arrest. If there's an arrest, or it hasn't been made at that point, that's when it proceeds. Just quickly, grand jury, as Lewis talked about, I was a federal prosecutor for a very short period of time. Only 12 people in the state system. The grand jury in the federal system is huge. It's a big horseshoe, and it's 23 people, I believe. And it takes just a majority, really 12 people to indict. So it's different, and in the state system, I would tell my prosecutors, you only indict for what the person did. You indict, not over-indict where you can plea bargain it down. The federal system, I find, it indicts for many, many charges, as Mr. Unglesby said, and they may end up indict for 25 and plead to 2. We in the state system really try to keep it. I like to truth in indictment, truth in what I do, truth in going in front of a jury. So it's not as mysterious as it may seem, but it's a fair process, and you can't indict a ham sandwich. You can't indict a ham sandwich. You have to prove that, and it's a sounding board, too, for what you may get in front of your real jury. Thank you.
Lewis, did you want to add any comment?
All I can say is this.
Can you come over here so we can catch on camera?
Just remember this. There's nobody ever been found not guilty that wasn't indicted first. Okay?
That must have been shocking news. Well, one thing I would say, we pride ourselves in trying to be fair. And as I looked at our panel, I realized it looked like it was weighted towards the prosecution. But then again, as I look at the criminal justice system, and I think about all of the people who are being brought before a judge or before a grand jury, maybe this is the appropriate balance. Because a lot are covered by not your clients, Louis. You can go out and hire an army. But I'm talking about public defenders that have a gajillion cases and we're not funding it properly. But that's a topic for another day. All right. Are there any questions out there? Joe?
Well, Prem mentioned that.
Can you stand up so we can hear you better?
Prem mentioned in the state system that the target can be in the room, and the attorney too. I wanted to ask Louis, since you probably have more experience in the federal system. I was always understood that the attorney, if the target testifies, the attorney goes outside and the target can take a break and confer. But I just want to get your take on just how that works in the federal system as far as the target.
Right. She's right. For a long time we couldn't, but in the last 20 years or so, they do allow in state court, the lawyer to bring his client in and watch. And it's an advantage from the perspective that I guess you hear get to hear the questions, you kind of see how your client presents, you see sort of where the prosecutor's thought process ideally is going, or at least the grand federal court do not. And it's a great mistake for anybody who's the target of a grand jury in federal court to go testify. I mean, I've represented former federal prosecutors and all that were in trouble, and they'll go do it, thinking they're going to talk their way out of it, And then they come back, and there's always an added false swearing or perjury charge, 100% of the time. Because, as they'll tell themselves and tell me out loud after they made the mistake of doing it, when I finally meet them, they'll say, we always waited and invited the guy we were going to indict last because we'd already decided he was guilty, and we just wanted to hear what kind of story he made up. So there's no advantage at all in the federal system to thinking that because you're an honest, good person that never tells a lie, that's going to get you anywhere. You're already, when you're invited, you're already indicted in reality. State system, I really don't know. I suspect that there are a lot of situations where people go in and make a good impression, and they have information, that the prosecutors didn't know, and it's new, and it's legitimate, And so then there's a reconsideration, and they do get to leave. I think sometimes there are cases where it's a courtesy, and a legitimate courtesy, where the prosecutor wants the defendant to come in because they're not sure if this person is guilty or if this person deserves the appropriate punishment they're thinking about, and they want to hear from them and see and it changes their mind. So in the state system, I don't have an opinion. In the federal system, it's a pre-cooked meal.
Hillar, do you or Prem want to add to that?
I don't want to follow Louis, but one thing I wanted to say is when Prem and I began selecting the jury, a lot of our citizens that came when they heard it was 6 months or a year said, I really don't think I can do this because of my job. My job's not going to pay. They're really not going to give me the day off. So what we started doing was to ask them for their employer's name and phone number. And we would step outside the courtroom and ask the employer, tell them how important the grand jury was. Will you pay or will you hold it against this person if they do it? So we a little more inclusive than that. The other thing I wish Prem had commented on is this. is that we have learned, seen that people that come to the grand jury come in there not really wanting to serve because it's a long time. However, at the end of it, these people have exchanged their names. They go to birthday parties, they do barbecues together, and they ask at the end, can we come back and serve again? It's an extremely eye-opening experience for us in the state system because they get to see the volume of bad things that happen to a lot of people. It's a really eye-opening experience for us in the state system, for these folks who are regular citizens that hear and see what goes on. And just like on a regular jury, we are fortunate in Baton Rouge when we have grand juries that are diverse grand juries, particularly black and white, and that live in different areas of the town. Because when they hear things, some can relate to certain language, some relate to certain streets or crossovers or whatever it may be, and they get to educate other jurors just like a jury does. And so we found that to be very beneficial for us to have a good cross-section. But you get the luck or the bad luck of the draw. You don't get to pick and choose grand jurors. It really comes out of they draw your name from a hopper, and that's how we get you. So it is a good experience, and I think that it surely can be abused. It just depends on who's making the presentation. But it's a really rewarding experience for the local grand jury. Good job.
Was it ever disallowed to have the client and the attorney in the same grand jury room, or it's just more accepted now? I think Lewis said something like 20 years.
I'm going to tell you, I was a defense lawyer for 16 years. I believe that over my objection, one defendant testified in the grand jury. Like Lewis, it's generally not in your client's favor to go before a grand jury unless there's a particular reason, or you've spoken with the prosecutor and you make sure that we're going to present this to the grand jury fairly. We don't know what the outcome is. There's no preconceived notion of what they're going to do. But I think it's rare that criminal defense lawyers allow a defendant to testify in the grand jury. And my experience of 16 years, one time, even if you invite the defendant, they really would choose not to testify.
So just so I'm clear on the two, a target can testify before a state or federal grand jury, but in the federal system, the attorney is never allowed in the room at the same time. Is that correct?
That's correct. And in federal court, I think that the witness can discuss his testimony afterwards, but in state court, you're not allowed to. It's the difference between the two.
All of you are community leaders and employers, and really, if Louisiana in America were progressive and thoughtful, nobody that's required to serve or selected to serve on a jury or a grand jury shouldn't get paid. And that's the biggest unfairness in the system when we talk about we want diversity, we want cross sections and all that. The reality is somebody comes in and they say, look, I've got 3 children, I'm a single mother, I work down at the hotel, and if I don't work, I don't get paid. Well, the judges said, you can go home. And the lawyers agree, of course you can go home. Your civic duty doesn't mean that you're supposed to go broke and you can't feed your children. Every employer ought to be required to pay their employee while they're serving on any kind of grand jury or jury, because it's not voluntary. And otherwise, what you get, until we changed the system, this happened in federal court all the time, it looked like the Rotary Club came down for jury service. And it was. They might as well have been on the bus from the meeting. Everybody worked for the federal government, the bank, or a plant as an executive, and they all got paid. So you never got a carpenter, or a truck driver or anyone like that. We need everybody, and the only way that could be is if all of us have to pay them when they get required to serve.
I'll keep taking your questions out there.
Lewis is absolutely right on that, and the system in the 42 years that, 41 of which I was a prosecutor, it changed a great deal. I remember the very first grand jury that I presented in front of was with O.C. Brown, and the foreperson of the grand jury at the time was Jimmy Boyce from Boyce Industries, and yes, it was like Rotary Club. Now we really, gosh, over the last since 1990, for example, and a little bit before that, it really is a cross-section of the community. You know, before that time, we never had a female to serve as the foreperson of the grand jury. In the last several years, we've had several women that were of several races, you know, be forepersons of the grand jury. That was even new. And how does the foreperson get chosen? That's random too. It used to not be. It used to be that the DA would kind of walk around the room and pick who he thought was the most responsible person. And, you know, that looks like, would you want to be the foreperson? Now it's all done randomly. It's like shaking box, the old-fashioned shake box. That's how they appoint the foreperson, the assistant foreperson, and you get someone then also to serve as the person, sergeant at arms, and then somebody volunteers to be the secretary, to keep the notes and the attendance of who was there. And there's a wonderful hierarchy of, you go back to the 1900s and see who was on the grand juries, the cases that they handled, what the vote was, because the vote is recorded in that book. So it's a great historical thing too, but to see how things have changed. And I've got to say, having a diverse community, crime happens in every segment of this community, and those grand jurors can give us, as prosecutors and as protectors of this community, a lot of insight, because different grand jurors will see it from a different standpoint. They will know the areas better. They will ask really good questions, things that we might not ask as experienced people. But they read people. Let me tell you, they can read people from their neighborhood so well sometimes that we, living in another area of town, don't see some of that. And they can just hone in like a human lie detector. So it's a very worthwhile process in the state court. And they ask things, and they don't just buy things from the DA being put in there either. They ask questions, and if they're not satisfied, they will ask for more evidence. They will lay the case over to the next week or the next 2 weeks, ask for additional witnesses, find out the names of potential witnesses. And I've seen grand jurors grill a person who was not being totally forthcoming to get the name of maybe somebody else that was out there. So it's wonderful. If you ever get called to serve, please do. As Hillar said, they start out with strangers. They don't really want to do it. And at the end of it, as the process goes on, you know, somebody will bring baked goods one day. Somebody will, if it's somebody's birthday, they know. They do little things while this is going on, just things as people bond. And then they do keep in touch. And you will run into people down the road who've been on a grand jury, and they'll watch their cases until the cases they've indicted, they'll watch the outcome. You know, I just love that. And I had one foreman one time call and go, I think that was the last case that we indicted that now has been tried. So it's wonderful.
Excuse me, I wanted to ask this. How many, I mean, it may not be stated right, but how many jurors must vote yea?
9 of the 12.
9 to 12.
9 of the 12.
9 of the 12.
Yes.
What about the federal?
Federal, it's 12 out of 23. It's a much larger grand jury. Like I said, when I first went to grand jury, big old horseshoe, and so many more people, and you're like, oh my gosh, look at this. Everything is recorded in there. That's also the difference. Everything is not recorded. Well, you can record people's testimony, but in federal court, they have a person who transcribes and is a court reporter in there. So a record is made of everything, and it's usually turned over at some point to the defense attorney. That is the difference. That's made discoverable like that. So that is turned over, and of course that court reporter has to be sworn to secrecy. And what you can say as a federal prosecutor is a lot different than what you can say in state court too, because everything you say is by Department of Justice guidelines, and you can't say much more than just question your witnesses, because it's turned over. And if you say something like, well, that guy had a record or something, your indictment's liable to be quashed by the judge. Yes, sir.
I have a question to ask. Between you and District 2, and the grand jury, do y'all ever come in conflict with the answer from the grand jury, and you all as DAs you know, I'm sure there are some time out of all the years that you have been working together, all your minds have not been on the same accord.
Absolutely.
Is there any time that you all get confused over the verdict that they may tell you, and you all have a verdict in mind yourself that you all want to use? What do you do in cases like that?
Some of those cases that I talked about that were taken to the grand jury that maybe were not cases that had to be presented. They might be, again, the traffic type cases, or they may be a case of a police officer, for example. And my practice was to take all those police officer cases to the grand jury and let the people decide. But a few times, you know, when I go in, I would honestly tell them, look, I can see a case, and I remember one case where there was a police chase, and honestly, I was very conflicted about it. Somebody had died during the course of, they were struck by a defendant being pursued, but it was actually the police officer's car. The first car, the defendant knocked her to the ground. The police officer's car is the one that killed her. And I told him, I said, you know, as unpleasant as it may be, you know, I don't really like this idea of a police chase. And I'm not so sure that this was right, that it might be negligent homicide. I told him, I said, you know, if you want to indict the officer, I'll try. That was just how I felt. It was like I was not going in to protect anybody. They came to their decision. Their decision was not to indict, but they, you know, they were like, this guy needs to be chewed out really bad. They don't need to be having these chases anymore. But yes, that kind of thing has happened. And sometimes it's like, okay, we'll do our best to try it, but it's going to be difficult. But that shows right there that you can't just indict a ham sandwich or tell them what to do, because that does happen. So, you know, it may be that, you know, 50 years ago or 60 years ago, somebody could go in and bamboozle people, or in some other parishes. This, you know, not everybody is East Baton Rouge either. I will say that I'm proud to have been a part of the system here. I'm a New Yorker. I came down and I wasn't sure what to expect in a southern area, to be honest with you, and wasn't familiar with Louisiana. But the first thing I told friends and family was I was so proud of the legal system in Baton Rouge, in East Baton Rouge Parish, the 19th JEC. Because I did have occasion, in my first job, which was with legal aid, to go across the river to several other parishes, and it wasn't exactly the same thing. You know, it was not. Justice was not the same. So, I mean, that I experienced as a woman in 1974. A Yankee, not from here. So there was a little towards the lawyer and the client too. So I've seen things change, but I am very proud of the justice system that we do have here. I am proud of the district attorneys that, by and large, that we have had in this parish, and what they do, and our judges, by and large. If there's a difference in judges too when you go to another jurisdiction, I've got to tell you. So I think we've been blessed with that. There's always room for improvement. There's no question. There's always room for improvement with public officials. But by and large, I think we are blessed in Louisiana to be here.
Lady here has a question.
Oh, okay, and I want to ask you, your cases that you have are grand juries determined by the characteristic of a case. For example, if you got a rape case, do you make sure you to women, men, old, young, you know, do you do like that?
At the trial, once the indictment comes down, it would honestly just depend. It would depend on the particular case. I found that women and men in most of the cases were good jurors. It would just depend the answers of certain people, and I think there's a lot more. Sometimes they say women are harder, you know, on other women. So it depends on the scenarios. It's a date, he said, she said kind of situation. Many of the rapes I had, though, were stranger on stranger. Somebody broke into someone's house. I had several women who were in their 80s raped. I had, in Garden District, I remember in the early 80s, 3 elderly ladies on all on different occasions that were raped by people who had broken in their house. In one case, she was a widow, working in her yard, left the home open, and he came in and waited in a bedroom till she went to bed. And in one case, the lady actually reached under her pillow. She got out a gun, she shot him, he had a collapsed lung, and they found a blood trail and got him in the hospital. I had a nun who was at St. Agnes on East Boulevard down there. A man broke in and attacked the nuns down there and beat them so badly. It was just an unbelievable case. And they came in to court in their Franciscan habitats. And I remember Doug Morrow was the judge, and he went, talk about dressed to kill. You know, he was like, but, you know, we've had all sorts of this. So it just depends. But I think you need to listen to that person's answers. And Hillar will know that too, from having been both a prosecutor and a defense attorney. It's the lead of that individual person. And you do have in your mind a certain type of juror before you start picking your case, but then you listen.
I want to ask one closing question. And this is directed to you, Hillar, and then if you want to comment on it, Prem. When you're in the grand jury and the prosecutor is the only one speaking, therefore it appears that all the information is being presented is in support of the case of the prosecutor. How can that be fair?
Well, the big difference is this is not a trial. This is only an accusatory process, and it's one that the law requires us to go. If we have information that's favorable to the defendant, that information is presented. If we know that information, if the defense lawyer doesn't provide us that, if we don't know it, we can't present it. We present evidence that's favorable to the defendant as well. Some legal scholars have argued that prosecutors should not be in the room in the grand jury at all, that somebody else should present the case to the grand jury, and if they have the true bill, then give it to the prosecutor. Not sure that's practical, that will never happen here, but again, it's just an accusatory process, and that's the way it's set up.
All right, thank you everyone for coming and supporting Coming to Learn and Lunch. And we invite you to come back on the third Thursday of next month, when we'll have another exciting topic. Also, everybody, remember your dues are due now. And for all of you who aren't members, please join us. It's a great group to be in. Thank you so much, and have a happy Halloween.